Number 36, Scurry versus NYCHA. Counsel?
John Watkins for the appellant, New York City Housing Authority. I'd like to reserve 3 minutes for rebuttal.
Certainly.
I'd like to also begin by congratulating Your Honor on your confirmation.
Thank you.
The two questions before you today, the question before you today is whether the Second Department rightly denied the appellant's motion for summary judgment. To answer that question involves answering two distinct inquiries. First, what the correct standard is to apply in such a case, and second, how that standard applies to these facts. So I'd like to begin by addressing the standard itself, which is framed for this court's review. There's no dispute here that as a landlord, NYCHA owed a duty to take minimal security precautions. And it's also not disputed on this appeal that there's an issue of fact as to whether that duty was executed or not. There's conflicting evidence in the record as to whether the locking mechanism for the apartment building actually functioned on the day of the attack. That's not a concession, it's just that's what's on the record. So for purposes of this motion today, I have to take it as true. I'm not conceding that it is true. The question is therefore whether there is a causal link, a proximate causal link between this alleged malfunctioning lock and the ultimate attack. There is not. There's ample jurisprudence for the position that a targeted attack, which by its nature will overcome the minimal security precautions that are the sole duty that a landlord owes in this situation.
Are you arguing that the targeted attack also extended to the son who was injured?
Yes, we are, Your Honor. That's correct.
How?
The Rivera case also has held from the First Department that when a bystander is collateral damage in a targeted attack, it's nevertheless a targeted attack because it's a targeted attack against the primary victim.
Can you have more than one proximate cause?
Yes, of course. There's no question that the jurisprudence is clear that you can have more than one proximate cause. Nevertheless, there's also ample jurisprudence that in some cases there is a cause that intervenes and supersedes. And that's what the jurisprudence that the First Department has been following for
And
the
even
last
if
several
we were
decades.
to accept that a targeted attack is sufficient here to grant you the relief you've requested, what evidence was presented that minimal standards had been met by the defendant?
As I said, there was in fact evidence in the record that the lock was functioning at the time of the attack, which would constitute our evidence that minimal standards have been met. But as I also just conceded...
That it was actually functioning when he entered?
Yes, there is evidence in the record reflecting that. Correct, Your Honor. However, there's also contrary evidence, and so in this procedural posture, I have to acknowledge that that's an issue of fact. My hands are tied.
So how would you have us, over here, sorry, how would you have us define targeted attack?
The case law uses a lot of language on that, Your Honor. Premeditated is one term that's frequently used. Another is when there's multiple parties involved. They talk about an intentional criminal conspiracy. Here there was one party, but I don't think there's any question that however you define intentional, premeditated, targeted, this meets that standard. And the evidence is overwhelming. This is a former romantic partner.
So the view is that because he was an abuser and he was intent on abusing her, she didn't get the protection of the lock would make a difference. Is that basically your argument?
The way you rephrased it just now, that the lock wouldn't have made a difference, yes, that is the argument.
Counsel, can I just ask you something so I'm clear on this rule, targeted attack? So it's, you know, the attacker, there's an ex-partner lives in the building, they show up with a battering ram, they go up to the door's open, they walk through, they go and they carry out this attack that they had pre-planned. And under the targeted attack rule, I'm assuming that would break the causal chain, right?
Yes, that would.
Let's say it's a random perpetrator who shows up with a battering ram, walks through the door, goes to the first apartment, knocks on the door, and attacks the person in there. Does that break the causal chain also, or no?
I believe it would, Your Honor, but
So
it
what do
wouldn't
we
be-
need a targeted attack for? Why isn't the issue really just, is the door make a difference?
That's a fair question. I think that the answer to your question is that a targeted attack in the jurisprudence that we're addressing from the First Department throughout the briefing.
Assumes a battering ram.
Right. A battering
why?
ram would be just as good. I'm agreeing with you. Similarly, proof that the assailant had a gun and could have overwhelmed the lobby attendant who was in the restroom at the moment that he entered, that would also suffice. There's a large number of things
But
that would
why does the
suffice.
targeted nature of the attack make the difference as to whether the minimal security measures would have made the ultimate difference in the case? Because if I have a battering ram, I'm getting through, no matter if I'm just somebody who wants to attack a random person in the building or I want to attack someone I had a relationship with, right? So why do we need the targeted part of the analysis?
You don't. The targeted part of the analysis is a subset of any kind of showing that's sufficient to demonstrate that minimal security precautions would not have prevented the attack.
But that statement seems to undo some of our settled case law, no? That is, if somebody is simply walking down the street, not intending to kill anyone, sees an open door, happens to have a gun, goes in and shoots a resident of one of your buildings, the proximate causation there is broken by that intentional act.
No, I disagree with that, Your Honor, and if you can allow me to parse out that distinction.
Sure.
What you just described as an attack of opportunity, where the person has seen an open door and with no premeditation to go through that open door, but they do have a gun, they have selected that opportunity because it's a soft spot and because it's an open or unguarded door. That is an attack of opportunity where, had there been a closed or locked door, the attacker would have had to go somewhere else.
So
This case is a case that involves a premeditated target. The target was Bridget Cruchon. She was being targeted no matter what. The assailant in question, Walter Boney, had left death threats, he'd stalked her, he'd assaulted her at her workplace previously. The evidence is pretty heavy in the record that he'd stolen her car. He'd left multiple threatening messages.
But he also tried to get into the house at some point, right? And she was behind a locked door, and he couldn't get in, and then he left. So why isn't that an issue for a jury to decide in this case?
That's the locked door of her apartment, right? On the
Correct.
previous occasion he was in the building.
He didn't know where she lived. He was knocking on every single door. No door opened.
I think the evidence is clear that he did, at the time of the attack, know exactly where she lived because he was waiting for her to emerge.
But he wasn't, this isn't in her apartment, that he entered a broken lock on her apartment. The manner in which she was attacked, you're saying it doesn't, even if he was bent on hurting her, the manner in which she was harmed here was still facilitated by the fact that that door was open. She didn't have an opportunity to retreat from him.
I would disagree with that.
Arguably.
He could have easily just attacked her, as we say in our papers, at the threshold of the apartment complex.
So is the
But that's
rule,
different. If they were outside at the threshold of the apartment building, any number of things could have happened. A passerby could have helped her. She could have run away. She could have rolled around on the floor. I mean, there's evidence in the record that she had nowhere to go, and neither did her son, because the hallway was engulfed in flames. Like, any number of scenarios could have happened had that door been locked,
I
right?
disagree.
Fundamentally, my question is, why are targeted victims not afforded the same rights and protections as non-targeted victims? In your case, a woman, a domestic violence victim in Brooklyn will always be a targeted victim. She's never allowed the protections, and she's never allowed to go to a jury to argue that if that door had been locked, I wouldn't have been hurt.
I think there are three questions there that I'd like, if you can afford me the time.
Of course.
I'd like to address them. And I may struggle because it was a compound question.
I'll remind you.
No, I think that a domestic violence victim obviously is entitled to the same rights as anyone else. However, when a domestic violence victim, for example, cohabitates with or has their romantic partner as a frequent guest, and that I think is the norm in domestic violence cases, it's very difficult to make a cause of action against the landlord for not excluding a resident from their own premises.
He didn't, here, he was not living with her at that particular address. So in your estimation, if you've ever lived with a person, you are subject to being attacked. There's nothing anyone can do, is your assertion.
No, Judge Troutman, I didn't say there's nothing anything could do, nor did I say those are the facts of my case. I answered the hypothetical that Judge Singas posed to me by saying that the landlord can't exclude another lawful resident. In fact, the case law is
Right.
legion,
So
and plaintiffs have actually
is your
agreed.
answer the same if it's not a lawful resident? That's what I'm asking.
No, the analysis is different, but
Okay.
I'm answering the framed question as best I can. And no, of course, we're not saying that people who are the victims of targeted attacks have no rights and have no recourse. The question is whether their injuries are the result proximately caused by the landowner's breach of the duty to provide minimal security. As the First Department held in a state of Murphy, one of the other cases before you today, there is no duty under the jurisprudence of the state of New York for a landlord to outwit or outthink a determined attacker.
Well, why isn't that a jury issue?
It isn't a jury issue because it hasn't been a jury issue, and because the issue of duty and the extent of a duty is always an issue of law for the courts.
Your rule seems to suggest that anytime it is a, quote, targeted attack, it will consistently supersede, it's intervening and it will supersede the duty that exists to provide a minimal amount of security. Am I phrasing that correctly, or can you envision circumstances where there can be a targeted attack and still a breach of the duty as you describe it?
Both our brief and the First Department in the state of Murphy rejected that interpretation, and we were very clear that we rejected that interpretation. So no, I have to disagree with the way you phrased it. Rather, the showing that the attack was targeted and that the attacker was of such a kind that he was able to overcome the minimal security measures shifts the burden and puts it on plaintiff. It becomes incumbent on plaintiff to introduce via admissible evidence that minimal security measures would have actually made a difference in the case. That's what the First Department said in the state
So
of
you are
Murphy.
saying that even the minimal, you don't have to, if you're moving as the movant, you don't even have to meet minimal standard of establishing that the minimal safety requirements were met. It's incumbent upon the plaintiff, is that what you're saying?
No, what I'm saying is that the showing that the attacker had targeted the victim creates the presumption that the determined attacker would have overcome the bare minimal security measures that are the duty of the landlord to provide. And that presumption is rebuttable by the introduction of admissible evidence to the contrary by the opponent of the motion.
Why-
And that actually does bring me, if I may.
Counsel, why do we have to shift that burden? Why can't we leave the burdens where they are? That, you established that minimal security measures were taken, and possibly leave it as a question of fact to determine whether or not the targeted attack approximately, was an intervening proximate cause.
Well, Judge, we're talking about two different elements of the tort, right? You just asked me why it's not my obligation to establish that minimal security measures were taken. That goes to breach. We're saying we can carry our burden as the element of proximate cause by showing that the attacker would have overcome minimal security measures in any case. That's a
Doesn't
totally
showing
different-
minimal security measures go to whether or not you met your responsibility, your duties with respect to the plaintiff?
I think that's what I just said. That goes to
I'm sorry,
breach as
counsel, maybe,
opposed to.
can I just ask a clarifying question? So are you saying it's your burden to show that even if there were minimal security measures in place, they wouldn't have made a difference? Or is your burden only to show this was a targeted attack and then the shift
Right.
goes over to the other party to say, they would have made a difference?
I'm saying that the jurisprudence that we're relying on, that we relied on in 2017 when this was briefed, and that we relied on here when we briefed it for you, from the First Department, has long held that those two things are the two sides of the same coin. That the targeting itself the premeditation itself by a determined attacker is sufficient to overcome minimal security measures, because minimal security measures are easily overcome, which I think is a fact of common lived experience.
Let's say we agree with you. We adopt this framing of the duty and the burdens. What, if any, impact does that have on the policy issues related to incentivizing landlords to provide adequate security? Even though if it's a minimal standard, I understand that. Does it have any impact on them?
It certainly doesn't have the dramatic impact that plaintiffs suggest in their brief, because that has been the rule in the first department and in the second department up until this decision that we're appealing from before you today came down. And so that has been the status quo. If there's a need to change that status quo, we think that that should have been addressed by the legislature. But I understand that I'm before a policymaking court now. The second department is not supposed to be a policymaking court. It's not supposed to be taking that decision into its own hands. And certainly it didn't do so on an informed basis, looking at facts and figures and statistics that showed it was necessary. This court could, of course, clarify whatever rule it wants to clarify. And it could, of course, reject the exact contours of my proposed rule, but nevertheless reverse the second department and accord an IHS summary judgment on the facts and record of my case. I did want to try to connect my answer to Justice Canataro's question to, I think, the first part of Judge Singhas's question. However, I have totally forgotten what that first part was. If you're able to remind me, I'll do my best. But I believe that the fundamental point that we were making is, because I was talking about the shifting burden, this is coming back to me, because I was talking about the shifting burdens, I wanted to address your initial question by saying I disagree, as I started to say, with your characterization of the record here. You said that there are a lot of facts in the record that suggest that this attack could have only been carried out where it was carried out. I disagree with that. I think there's no facts in the record that suggest that. Plaintiff tried to make that showing with an expert affidavit from his security expert. I would urge the court to look at that expert report. It's 8 pages long. It's 21 numbered paragraphs. The first 19 describe the building, the parties, and the incident itself. The 20th paragraph issues the conclusion with a reasonable sense of certainty that the malfunctioning locks constituted a breach of the duty to provide minimal security measure. So far, so good. The 21st and final paragraph simply states in a conclusory fashion that therefore this was a proximate cause of the attack. That's all there is. If we had a different record, because of the question I was asked about how does a plaintiff raise an issue of fact, or are they right out, as Judge Garcia asked me, if we had a different record, I think we would have a different case. If we had an expert who said, and a functioning lock would have prevented this accident, and here's how.
But
That would have
again,
been-
That's
for
not, because
clarif-
you can have more, as I think Judge Troutman, or one of the sisters to my right has said, the reality is that you can have more than one proximate cause. So it actually isn't that you have to show that, but for this lot, this is the only reason, right, for this injury. It can be
Of
one
course.
of the reasons for the injury.
It can be a reason that is an actual reason fairly applied in law, a proximate cause.
It does
not-
seem
not merely
obvious
a
if they
cause in
can't
fact.
get through the door, at a minimum, he would have been slowed down, at a minimum,
But
even if he
slow-
eventually got through the door.
There's
And
no
those
evidence
precious
that-
seconds might have made a difference.
There's no evidence for that
But
whatsoever
that's for
in
the
the
jury,
record.
right? That's the
No,
argumentation to the
I-
jury.
But
I
I'm going to
disagree.
disagree with you on that. There's no evidence. On the Murphy case, we can actually see on the videotape when the assailants entered in. And I think if they had been slowed down, or at least there's an argument to make to a jury, if they had been slowed down, they tried the first door, it was locked. They get to the second door, it swings open, they run in. Maybe an extra minute or two would have enabled her to get into her apartment, and they wouldn't have known where she was. And just on that thought, is the victim in Murphy the same targeted victim that you see or you're describing in Scurry? Do you see any difference with that? Because again, like, where does opportunity come in?
I have to defer to my learned friend, Mr. Lawless, to discuss the particulars of the Murphy case because it's not my case.
Okay.
But even if there's admissible evidence in the Murphy case that a second might have made a difference, there is no such evidence on this record because
But it
as
is
plaintiff-
common understanding that they would have at least been slowed down. Whether or not it would have been enough time, that's the jury issue.
This
But there
case-
can't be a dispute that there would have been some amount of slowing him down if he can't open the door, even if it's seconds. Maybe the jury would not have found that seconds is enough, but nevertheless, sounds like a jury question.
I have to disagree. This isn't a case of someone giving chase. So there is no issue of seconds. This is a case of someone who entered the building and lay in wait for an ambush. So a second or a minute here or there, there's no evidence that would make a difference.
Okay, thank you,
whatsoever.
counsel. You have your rebuttal.
Thank you.
May it please the court, Brian Chute, I represent the Scurry plaintiffs. I'm at a loss as to which
You're right,
argument to
because it's a
respond.
question of someone laying in wait, that it really doesn't matter if the door, even the door would have slowed them down because they eventually would have gotten in and then just waited, as they did here.
We're talking about the Murphy case there. Yes, it would have made a difference, and yes, who knows what difference it would have made in that case. I'm at a loss as to which argument to respond. The argument that the defendant made in both of the lower courts, which had nothing to do with burden of proof. Their argument was targeted plaintiffs lose, period. It doesn't matter what you prove, it doesn't matter what I prove. If they're targeted, they lose. Or the argument now in this court, which is it flips the burden of proof. Be
Whose
that as it may.
responsibility is it when you're a movement for summary judgment?
Obviously, Your Honor, and I take it it is the burden of the party moving for summary judgment. Probably 100 cases of this court say just that.
And does it make a difference that someone is targeted? Does that change that rule?
The position is threefold, Your Honor. First, both the lower courts, the First Department and the Second Department, Scurry and Murphy, I think were correct in rejecting the notion that there's a special anti-tenant rule in premises security, that there's a special rule of causation just for these cases. The Justice Dillon's decision on behalf of the unanimous panel rejected that. The First Department decision disowned that principle. And I think closer to what Judge Garcia was suggesting, the issue ultimately is when you consider all the facts, not one fact, all of the facts, did the absence of security make a difference? And of course, on a motion for summary judgment,
Yeah, your adversary seems to be saying, as I understand it, that they meet their burden on that issue, that no reasonable security, minimal security measures would have made a difference by just saying targeted attack.
there's absolutely no decision of this court that ever says it, that said that.
Do
The
you think
First
that's an
Department,
accurate-
which actually literally had said that in some cases, just disowned it in Murphy. We didn't mean that. What we really meant was you consider all the facts. There is no special rule. What's more, this court in Burgos rejected the notion that there should be a special anti-tenant rule in premises security cases because the court reasoned to do so would place an impossible burden on tenants and would, quote, undermine the deterrent effect of tort law on negligent landlords, diminishing their incentive to provide and maintain the minimally required security for their tenants.
Well, how so on that? Because I did press a little bit here, and we didn't quite get to this. How so on that? Because this, regardless whether it's a tenant or a non-tenant, someone otherwise is lawfully on the premises, they do have to worry about the non-targeted tenant, right? They've got to provide the security, otherwise it's not like they're going to leave the door open thinking they're in a better position to avoid tort liability.
Yes, yes, of course. That should be a concern. There's a short answer, a longer answer, and I think an ultimate answer to this entire appeal here. Here's the very short answer. The move-ins papers you'll find at pages 19 to 36, they're moving affirmation of the record. Not only is there no evidence of the kind this court deemed admissible in Price versus Housing Authority to the effect that a working door would have made no difference, there is no contention in their moving affidavit that it would have made a difference. What is more, when you look at their reply papers in this case, specifically pages 21 to 44 to 21 to 45, after we come up with our proof to the effect that, yes, the door made a difference, yes, it was one of the causes of this, their response is, that is beside the point. And our discussion of whether that door was a proximate cause was simply intended to distract, because according to the lower
So
court...
is your position that on the motion for summary judgment, their burden was to show that it was not a cause at all? Not that it was not the most significant cause, but just not a cause at all?
Absolutely, Your Honor, as in every single other tort case. In premises liability, in
Well, there
any...
is an outer limit to causation, too.
I'm sorry, I
Right? I
missed
mean,
that.
there is an outer limit to causation, too.
Sure,
Right.
and duty defines a boundary.
So why isn't this on that outer limit, given that the duty is minimal in terms of the security device we're talking about here?
Why is it? Because their duty is not much, which gets me, I think, to what I was going to say is the ultimate issue. Their burden, Your Honors, is so small. Provide a working lock. Provide minimal security. Just do that. If you do that, then there are no hypothetical questions of whether the assault would have occurred if you had a working lock, because you would have had a working lock.
There's not a question, that I think, for this appeal, that they had a duty and they breached a duty, right? The question really turns on proximate cause, and at least as I see it, and correct me if you think differently, the question really is whether what they're calling a targeted killing in some case, or in this case, or in any case, could ever be the sole proximate cause, so that even though the breach of the duty in the absence of this targeted killing would render them liable, something happened that in this case, the targeted killing, that is the sole proximate cause. That's, I think, what they're arguing.
And yet, that's, of course, utterly inconsistent with this court's decision in Nallen, where it was a would-be assassin who committed the murder in the lobby of the building, and with most of the cases cited in my brief, where they were all intentional torts. In both Gomez, which was the case combined with Burgos, and Jacqueline S., all of these are crimes that are intentional, every single one.
Is that the choice here? Is the question we're being asked to answer whether a targeted attack will always be the sole superseding cause, or can't, or won't always be? Or is there some middle ground where a defendant seeking summary judgment or defending against summary judgment could show that the causal chain has been overcome? The burden has been overcome.
You seem to be asking me what their contention is, and their contention, that was their contention in the lower courts. It seems to be no longer their contention in this court. But it's inconsistent with numerous decisions by this court that that's an intervening or superseding cause, and it makes no sense. And there's a statement that then Justice Littman made in the Nash versus Port Authority case. That was the World Trade Center bombing case, on an issue which this court didn't consider because it didn't have to. But the argument there was that these are the terrorists who bombed the World Trade Center. They're going to do it, or they're going to do something terrible, no matter what you do, the defense argued. And writing for a unanimous panel of the First Department, Justice Littman said it will always be possible to hypothesize the circumvention of security precautions, particularly those of the sort so frequently described as minimal, But the fact remains that such precautions must be supposed to provide some margin of security, or the landlord's duty would be routinely excused as futile and rendered nugatory. Here, it is so little that they have to do to maintain their buildings. And it's wonderful that the concession is that there's some proof that they failed to do so. For example, their own records say that of the 103 days preceding this incident, according to their records, that block was functional on 10 of them. Their records, pages 1810 to 1914 of the record. The longer answer, if the court would like the facts of this case, and why I shouldn't even have to address this, because the short answer is there was no prima facie case for summary judgment. But let's talk about the facts of this case and how that DOA mattered. This is not a person with a gun who shoots the plaintiff. He's got a can of gasoline. What are his odds on waiting outside the door patiently with his can of gasoline, dousing her there, and that no one's going to see it, no one's going to intervene, she's not going to be able to roll, she's not going to be able to run? What are the odds of him being able to complete it then, his plan of dousing her with gasoline and setting her afire? He has her in a place, the perfect place he can get in without being seen. The door's broken. He has her trapped in a hallway. And even though he had her trapped in a hallway, she was almost saved. Her son, coming from behind the locked door, pulled them apart. Seconds too late, the perpetrator managed to throw the match and set them aflame. If he, the son, had been 10 seconds, 20 seconds earlier, this would not have happened. And there's no argument, no proof certainly, that indeed the same thing would have happened outside the building or on some street corner at her workplace, that he would have been able to complete this crime of dousing her with gasoline and setting her aflame without being interrupted.
But the rule that a tort plaintiff is going to die later because of some other cause doesn't really seem to find a place in any jurisprudence I know of.
Absolutely. And again, that was also considered, Your Honor, in the Nash case, where the First Department noted it was unprecedented. In no other context do we consider, well, if there wasn't a crash at this intersection, it could have been the next intersection or the next day. Maybe the injuries would have been worse at the hypothetical accident that didn't occur because this one did. That's never a defense. If it were a defense, there'd be no causation in tort law. It's never been a defense. Does the court have any?
Thank you.
Thank you.
Counsel?
Thank you, Your Honors. I'm just going to go quickly through a couple points, unless you have further questions. First of all, my learned friend just made a point regarding the arguments we made below, and he said that our argument below was completely about severing the causal link as a matter of law, and that there was no address of the shifting of burdens. That's not correct. The language he uses in his brief to support that is from a preliminary statement. In fact, both arguments were advanced below in the alternative. The issue is certainly preserved for review. I want to turn to this issue about the burden. I just heard my learned friend talk about how the burden is so low on us, all we have to do is establish that we complied and that we weren't negligent. That's about one element. I think the questions directed at him were cogent in that they highlighted the fact that the rule proposed by plaintiffs here and the rule proposed by the Second Department is effectively that a landlord in a case such as this can never carry his burden on summary judgment as to the element of causation. And that's wrong. To your point, Judge Rivera, there is a limit to causation. Even this court in the Hain case said that when there are acts that are so abnormal that they attenuate the link between the initial negligence and the ultimate result, that can entitle someone to summary judgment on proximate cause. Even if my framed rule, the framed rule we've placed before you in these briefs, is not to this court's liking, the rule adopted in plaintiff's brief and by the Second Department that the only way to carry the burden on proximate cause is to show that no level of security could have possibly prevented the attack, is effectively to say that a landlord's duty is not to have minimal security provisions, but is in fact greatly expanded. I don't think that's called for on these facts. I don't think this case is the case to make that change. And I don't think I don't think there's any reason to expand liability in that manner. I want to address another point about causation. Judge Wilson, I disagree with something that you just asked about this not finding a role in our jurisprudence. In the Tartar case, in fact, the First Department did state that because the attacker, who like in this case was the plaintiff's former lover, was bound and determined to do her violence and was stalking her from place to place in order to do so, it would be inequitable to hold the landlord of the place in which the attack was actually carried out to be a co-tortfeasor because of the happenstance of where the pounce occurred. That is the rule that we urge that the court consider today. We urge that the court consider that when an attack is targeted and bound and determined to occur sooner or later in one place or another, it is inequitable to treat the particular landlord on whose premises it occurred as an insurer of the loss. If there are no further questions, we rest on our briefs.
Thank you.